This week, the topic for our in-class treatments is federalism. And I think I might have mentioned this to you on the first class meeting, that federalism is such an important topic in the study of our system of government that we actually take a stab at it, take a swipe at it in both the 2305 and the 2306 classes. So those of you who have taken the government 2306 class, or excuse me, the government 2305 class, probably will remember at least some of the things that we talk about in today's class session, because I can't just assume that everybody's had government 2305, or even if you have 2305, how much of that treatment of federalism you still remember. So we're going to start very broadly here in our discussion of federalism, but by the time we finish with the Thursday class session, which will be recorded for you, we'll be talking in a much more specific way about how the principles of federalism apply here in Texas. Okay, so start very big picture. I want to suggest to you that every political system, or virtually every political system in the world today, has some arrangement where you have a central government and regional governments. Okay, the two basic types that you see if you're looking at this map up here on the screen, you can see that most political systems around the world can be characterized as either unitary systems or federal systems. But in the title up there, it also says confederacies or confederal systems. And the fact of the matter is that it's hard to identify examples of confederacies today or even historically because they're few and far between. But I think it's important for us to talk about confederacies, if for no other reason than as a frame of reference, as a reference point, particularly to understand the American federal system. So more on that here in just a bit. Initially here, I want to start with this distinction between unitary and federal. Okay, so if you were to actually count up the countries here that are shaded in blue, that indicates the countries that have unitary systems. Count up the countries that are shaded in green. Those are the ones with federal systems. Which one is more common?
Looks pretty half and half.
If you're looking at, like kind of aerial coverage, like geographical coverage, it might look kind of half and half. But actually, there are more unitary systems. There are more countries with blue if we're just counting up countries. Okay, but that doesn't mean there's no shortage of federal systems. There are lots of federal systems. The United States is one of several. At any rate, as I started to say, whether we're talking about unitary systems or federal systems, or for that matter, confederacies, you're really talking about an arrangement where you have a central government and then some regional governments. The real question is, what is the relationship between the two? Okay. The fact that pretty much every country today in the modern era has some kind of arrangement between central government and regional governments, I think owes to the largeness of the modern nation state. The modern nation states are large, both in terms of geography and in terms of people. It's not like the old city-state arrangements that they had in ancient Greece, right? So you got a lot of territory and you got a lot of people to govern. And it's really not practical to think that all that territory and all those people could be governed from a central location. So you're going to have, whether we're talking about unitary systems or federal systems, you're going to have some sort of arrangement where you have a central government and then regional governments. Okay? As I said, though, the distinction is in what the nature of that relationship is. So let me start by suggesting to you the nature of a unitary system. In a unitary system, the central government has the power, and it typically delegates power to regional governments that act mainly as administrative subunits of the central government. That's, I think, the simplest way to describe a unitary system. You have these regional governments, but they are really, for the most part, administrative subunits. They have no real authority of their own. Whatever authority they have comes from the central government. Now, this distinction here that I've got this little asterisk point, it really is a footnote, particularly for our purposes. Look, I guess maybe what I'll say here, just to sort of get past that part, if you're wondering about what that part means, this distinction between unitary and federal really doesn't tell us much about the types of governments that they have in terms of democracy versus autocracy, right? Because there are democratic systems that are unitary, there are democratic systems that are federal. There are unitary systems that are autocratic, there are unitary systems that are, or there are federal systems that are autocratic. Did I get that right? You understand what I'm saying, right? This distinction between federal and unitary really doesn't tell us much about the nature of power in terms of like how democratic it is or the lack of democracy. Okay. For example, North Korea is an autocratic system, right? It's a unitary system. Great Britain is a unitary system. It's a democracy. They're both unitary systems, but one's a democracy and the other's an autocracy. Right? So just put that part of it aside, okay, in favor of just understanding for now, just understanding this relationship between the central government and the regional governments. Again, the basic idea is that power flows downward, that the regional governments have no real authority of their own, that they get whatever authority they have from the central government, and for the most part, they're acting as administrative subunits. Okay? So here are a few examples of countries around the world today that have unitary systems. The United Kingdom is an example of the unitary system. You have these regional subdivisions, the counties, but also like Cornwall and Wales. And Scotland is kind of an exceptional case. Some of you may be aware of that because they have quite a bit of autonomy in Scotland, but you know, for the most part, the power is here in London, okay? And the regional subdivisions are acting mainly as administrative subunits. Japan is a unitary system. They have, forgot the exact number. It seems like it's in the 80s or 90s, something like that. What they call them prefectures in Japan. But again, they really just act as administrative subunits of the government in Tokyo. That's where the real governing authority is. Okay? Saudi Arabia is an example of a unitary system. The real power is here in Riyadh, particularly the royal, the king. Right? So look, here's a democracy that's a unitary system. Japan is a democracy, and here is an authoritarian system that's a democracy, or that is a unitary system. Here are the provinces anyway, or the regional subdivisions in Saudi Arabia. Okay? A confederacy, I said that it's hard to come up with examples in the world today and even historically because they're few and far between. But it's essentially the opposite idea, isn't it? Right? Because what this is suggesting is that the regional governments have the authority and they may delegate some authority up to a central government, but that the central government really doesn't have authority except that which is delegated to it by the regional governments. So the power is flowing in the opposite direction. In a unitary system, it's flowing from the central government to the regional governments, and in a confederacy, it's flowing from the regional governments to the central government. Here's an example, historical example of a confederacy. The United States, in the period from independence in 1776 to the time that the Constitution went into effect in 1789, so a dozen or so years, about 13 years there, where the United States operated as a confederacy under the Articles of Confederation. And it really was the reality. It was the accurate representation to say that the United States in that period, each individual state was essentially its own country. And it was just a little more than a treaty organization among the original 13 states, the Articles of Confederation. In fact, the Articles of Confederation itself refers to the United States as a league of mutual friendship among sovereign states. It didn't take the Americans very long to figure out that that was unworkable, as confederacies generally are pretty short-lived and they're not terribly effective systems of government. when the Soviet Union collapsed in 1991, the old USSR, Union of Soviet Socialist Republics, what emerged to replace it? This thing called the Commonwealth of Independent States, which back in those days, if you were to go back and look at news accounts from the early 1990s, you would see some articles that mention the Commonwealth of Independent States, but you really don't hear about it anymore. I don't even know if it exists even on paper anymore. But even if we go back to the early 1990s, it was a little more than a paper organization. The Russian Republic, right, which, you know, Americans back in those days kind of equated the Soviet Union with Russia. But there were other Soviet republics, you know, the Central Asian republics like Kazakhstan and Uzbekistan and Turkmenistan. And then there were the Caucasus here, Georgia and Armenia, right? And then there are the Baltic republics up here, Estonia, Latvia, Belarus, and Ukraine. All that was part of the old Soviet Union, right? When communism collapsed in 1991, sort of disintegrated, you did have this, as I say, at least a paper kind of arrangement here among the former Soviet republics called the Commonwealth of Independent States, but it wasn't, practically speaking, a workable form of government. Each of these countries, in fact, to some extent, most notably countries like Russia and Ukraine have really drifted apart, right? I mean, you're aware that there's some tension now, right, between Russia and Ukraine. It has been for some time. The best example I can give you today of a confederacy is the United Nations. The 193 members of the United Nations are a confederacy. And it's important to note that each of the member states, each of the member nations, retain their sovereignty. And they aren't about to give it up. The United States is not about to give up its sovereignty to a world government called the United Nations. Russia is not about to give up its sovereignty to a world government called the United Nations. The United Kingdom, Japan, France, Germany, India, Israel, none of those member countries, I can't list all 193, okay? None of them are going to give up their sovereignty to the United Nations. You have some central organs of government in the United Nations, the General Assembly and the Security Council, but there's a reason why most people, Americans and people really around the world, perceive the United Nations as ineffectual. There's not much that the United Nations does, most of us would say, very well, very effectively. Oh, they might give out, some food, in a food program during a time of famine, right? Maybe they do that okay, right? But in terms of governance, most people's conclusion would be it doesn't work very well. But that's the nature of confederacies. And it's what the Americans figured out by 1787 when they wrote a new constitution. The confederacies just don't seem to, they're not very practical. Federal systems look very different, don't they? Because in a federal system, neither level of government gets its authority from the other. The the central government doesn't get its authority from the regional governments. The regional governments don't get their authority from the central government. In fact, they both get their authority from whatever the sovereign power is. It's easier to talk about in terms of democratic systems like the United States, but at least in theory, we can imagine a federal system where you have some authoritarian figure at the head of the entire thing. And, I think, I'm certainly not an expert on this, but I think that at least technically China is a federal system. The old Soviet Union would have been an example of a federal system. Okay, so the regional governments get their authority from the sovereign. The central government gets its authority from the sovereign. Neither gets their authority from one another. That's a very key point about federal systems. Okay, so here are some examples. India is a federal system. I believe they call them states in India. Does anybody know? Yeah? You know how many there are?
29.
39?
29.
29, okay.
Can you go back real quick? I didn't know what was in this.
There?
No.
Oh, here.
Oh, central government.
Yeah. Okay. So India, Nigeria is a federal system. Germany is a federal system. You know, there used to be an East Germany and West Germany, right? Before 1993, I think, when that was reunified, right? East Germany was formerly the German Democratic Republic. That was the communist state, right? West Germany was the German Federated Republic. And when they merged, it was just the German Federated Republic. So they have states in Germany, right? Just like we have Texas and New Mexico and Arizona, they have Bavaria and Hessen and Westphalia. Brazil, the federal system, they're the states of Brazil. Here's an interesting one. Canada, our neighbors to the north, is a federal system, although they don't call them states in Canada, they call them provinces. Ontario has been in the news here recently, right? For those of you who pay attention to the news. The protests going on in Ottawa and the complaints of many Canadians, why doesn't the federal government do something? Or even the provincial authorities in Ontario. Why don't they do something? At any rate, just like they have Ontario, Manitoba, and Saskatchewan, we have Montana, Minnesota, and North Dakota. Here's a good one to our south, Mexico. There are the states of Mexico. Have any of you looked at ever held a Mexican peso, looked at a Mexican peso? It says on there, Los Estados Unidos de Mexico. The United States of Mexico. So Texas, Arizona, New Mexico, Sonora, Chihuahua, Coahuila. Okay? Lots of different federal systems around the world. Those are just a few examples. Obviously, the United States of America, our country, is a federal system as well. Okay? All federal systems have a number of characteristics in common. There are several characteristics that are true of all federal systems. So I'm going to run through these here. I want to run through these as quickly as possible, but I don't want to suggest to you that if you have questions, not to ask. Okay? I mean, if you have questions, please interject them. Okay? But let's just run. There's several bullet points here that I want to run through. Okay? So all federal systems have a number of things in common. First of all, there's a constitutional division of governmental powers and responsibilities such that each level is autonomous in at least one sphere of action. That word autonomous means that they can act under their own authority. There's at least one area where the central government can act under its own authority, and at least one area where the states or the regional governments can act under their own authority. I'm going to stop saying central and regional because it's not natural to me. I'm going to say national and state. Okay? Because that's what we say in the United States, national and state governments. One area where the national government can act, at least one area where the national government can act, at least one area where the state governments can act. So autonomy here means the same thing for governments as it means for people. Right? If you have personal autonomy, that means you can make decisions governing your own life. Generally speaking, we say that adults have autonomy, unless they're incapacitated in some way, right? Children, not so much autonomy. I guess it depends on who their parents are. Right? But you understand the point that I'm making. It just means the ability to make decisions for oneself when we're talking about personal autonomy. So it means the same thing at a governmental level, the ability of Texas to make decisions for itself, the ability of Wyoming to make decisions for itself, the ability of the national government to make decisions for the entire country. Each government, that is to say national government and then the state governments, are final and supreme in their constitutionally assigned spheres. So if it is an autonomous power of the national government, when the national government undertakes that authority, it is final and supreme. If it is an autonomous power of the state governments, when they undertake that authority, it is final and supreme. By the way, the word autonomous doesn't mean that one can do it and the other can't. I want to be clear about that. That's the notion of exclusive authority. So don't confuse those two things. For example, in the United States, in our federal system, the national government has the exclusive power to declare war. Texas can't do that. Okay? The national government has the exclusive power to coin money. Texas can't do that. But we're not saying exclusive here, we're saying autonomous. There are some powers that both can do, like say the power to tax. The national government has the autonomous power to impose taxes. The state governments have the autonomous power to impose taxes. There are lots of areas. That's just, I think, the example that most people can appreciate immediately. You're aware that both the national government and the state government is taxing you, right? Occasionally I'll have a particularly sharp student who will say, on this one, will say, hold on, wait a minute. Doesn't sometimes the national government invalidate state laws? And I said, well, what do you mean? I had a student just last semester who raised this issue. And she said, well, like Texas had a law. In fact, we talked about this last week. When voters in Texas in 2005 approved the constitutional amendment prohibiting same-sex marriage in Texas, right? We had a referendum, 2005, and a majority of Texas voters said marriage is going to be defined in Texas as a arrangement between one man and one woman, which presumably means that same-sex couples can't avail themselves of that status. But what happened to that law? Anybody know? Is that the law in Texas today? Or anywhere in the country for that matter? As a result of what? I see a couple of people shaking their heads, no, it's not the law in Texas. Is that because that amendment to the Texas Constitution was repealed by voters in the same way that they approved it? No, that didn't happen. The United States Supreme Court struck down, it was in a case that came out of Texas. I think it came out of Ohio, and one came out of Ohio and one came out of Kentucky. I think those were the two states involved. It really doesn't matter. Two other states that had prohibitions against same-sex marriage, and the United States Supreme Court in 2015, only about 6 or 7 years ago, struck that down. Right? Said no, states can't have those kind of laws. So that would include Texas. So how do you reconcile that fact with what I'm saying here? That once the state in Texas, the mechanism was a constitutional amendment. Once they prohibited same-sex marriage, how can the national government, the Supreme Court of the United States is an institution of the national government. How can the national government come back and say, nope, we're not going to let you do that? The key phrase is this, right? In its constitutionally assigned sphere. In other words, the Supreme Court was saying it's not in Texas's constitutionally assigned sphere. It's not in Kentucky's or Ohio's or any state's constitutionally assigned sphere to deny a marriage license to same-sex couples. So it has to be within their constitutionally assigned sphere in order for it to be final and supreme. There used to be a law in Texas that made it a crime to burn an American flag, to desecrate a venerated symbol, is the way that the law was phrased. And there was a case, this case actually did come out of the state of Texas, right? Involved a man by the name of Gregory Lee Johnson way back in 1984, who was protesting out in front of the Republican National Convention that was being held in Dallas that year when Ronald Reagan was being renominated by the Republican Party for president. And he was inside wrapping himself in the American flag and red, white, and blue and talking about morning time in America and all that kind of patriotic messaging. Gregory Johnson and his band of aging hippie malcontents were outside protesting, America, the red, white, and blue, we spit on you. And he, at some point, takes out an American flag that he had in a backpack and douses it with some incendiary fluid, kerosene or something, and sets it on fire. And the police swoop in. And they place him under arrest and charge him for violating that Texas law that prohibits the desecration of a venerated symbol. And he was convicted and given a prison sentence. And he appealed his conviction, goes to the United States Supreme Court, and the Supreme Court says, Texas doesn't have the authority under the Constitution, in this case, to restrict this man's free speech rights. That it is protected speech. That when Ronald Reagan is wrapping himself in the flag and articulating some patriotic message about morning time in America, he's using the flag for that purpose. Gregory Lee Johnson is also using the flag for his speech, for his purposes. He's sending a message, a very powerful message. We may not want to hear it. We may not like it, but he has the right to do it because the First Amendment protects that right of free speech, including against the authority of the laws of the state of Texas. So again, that was just, another example of how it has to be within the constitutional authority of the state in order for it to be final and supreme, or any government, national or state. Can't be final and supreme if it's not constitutional. That's what I'm trying to say. Both levels of government derive their authority from the sovereign rather than from one another. So that's the point that we made here, right? They both get their authority from the sovereign. Central government doesn't get its authority from the regional governments. The regional governments don't get their authority from the central government. Who or what is sovereign? Well, in a democratic system, the quick answer to that is the people. But in the American system, how do we know what powers the people want the national government to have? How do we know what powers they want the state governments to have? They delineate that in a written constitution that begins with the words, we the people. Here's the powers that we want here's the powers that the people want the national government to have. Here are the powers that the people want the state governments to have. So they both get their authority from the Constitution. And it must be consistent with the Constitution, as we said. Here's a big one. This is, as a historical reality in the United States, this is a big deal. The Constitution, when it went into effect in 1789, fundamentally began the transformation of the United States in this respect. Now, under the new Constitution, both levels of government, national and state, can act directly on individual citizens. As my example of taxing suggests, right? The national government can tax you directly, the state governments can tax you directly. But as a historical fact, this was really, at a philosophical level, the point that separated the Federalists and the Anti-Federalists. You remember from your Government 2305 class, or maybe your American history class, that you had these two factions, those early debates, okay, over the Constitution. And the Anti-Federalists were generally opposed to the ratification of the Constitution, right? Maybe that's a difficult point for Americans in the year 2022 to appreciate, because I think today we kind of imagine that back in the late 1780s, when the Constitution was written, that, the framers of the Constitution were these great men, and they were, but the naive part is that we kind of assume that they all, had the good of the nation in mind, and they were above politics and all that sort of stuff. They certainly were not. And there certainly was no agreement on the merits of the Constitution. There was not universal agreement on the merits of the Constitution. Americans today look at it and go, oh, wow, if only we had political leadership like that today. Who questions the wisdom of the Constitution today? Nobody. We debate within the context of the Constitution. But I'm telling you, if it's news to you, if it's upsetting, I'm sorry, right? But the truth of the matter is that there was not consensus on the merits of the Constitution at the time that it was written. How many of you, just a quick show of hands, how many of you are aware of something called the Federalist Papers? Okay, the Federalist Papers were what? Say that again? There were James Madison and Alexander Hamilton wrote the bulk of them. There were actually, I think, 3 others that were written by John Jay. But you're right, Hamilton and Madison were the primary authors. What was the purpose of the Federalist Papers? It was to convince the readers, mainly the people of the state of New York, that the Constitution merited ratification. 85 essays. Can you imagine your English professor assigning you one essay to persuade your readers of some point? Imagine writing 85 essays. Why would they possibly think that it's necessary to write 85 essays if the wisdom of the Constitution is apparent to everyone? The fact of the matter is that there was real opposition to the ratification of the Constitution. And one of the main points that the Anti-Federalists, again, at a philosophical level, took issue with was that this new government that was going to be created, this new central government that was going to be created by the Constitution, would have the ability to act directly on individual citizens. Congress would have the authority to lay and collect taxes. Under the Articles of Confederation, Congress could only request revenue from the states. Congress would have the authority to raise and support an army and navy, draft you, if necessary, into the military. Under the Articles of Confederation, they could only request militia from the states. And those are just two examples, right? So that's why the Anti-Federalists, like, particularly like people like Patrick Henry, right? Wrong one. Patrick Henry, who was a delegate to the Virginia Ratifying Commission. This Constitution was written in the summer of 1787. And then it was submitted to the states. And what I'm telling you is that there were several states where there weren't enough votes to get it ratified. New York was one. That's why the Federalist Papers are directed to the people of New York. Massachusetts was another one. Right? In Virginia, Patrick Henry, one of the leading anti-federalist opponents of the ratification of the Constitution, was so enraged by three simple words: "We the people," that he rises to the floor of the ratifying convention and beseeches his colleagues to tell him who gave these men the authority to speak the words "we the people." How dare they speak the words "we the people"? Because Patrick Henry, like the other anti-federalists, understood the United States to be a union of states, not a union of people. And this new Constitution was going to transform what they had pretty much happy with, a union of states, where Virginia was an independent state, and South Carolina was an independent state, and so on, to a union of the peoples of the states. And that worried them because they understood that, he says, extremely pernicious, impolitic, and dangerous. But it's because ultimately it comes down to this, right? They knew that this new national government was going to have authority that the old central government didn't have under the Articles of Confederation, and that is to reach out and touch you, all your lives. They didn't like that idea very much. So that's a big difference between confederacies and a federal system. It's just like the United Nations today, right? The United Nations can't reach out and tax you. It's a confederacy. The United Nations can't conscript you into an international army. Now, if you are a member of the United States military, then the commander-in-chief says that, American troops are going to participate in a UN force, that's a different story. But you're acting under the responsibilities imposed upon you by being a member of the United States military, not by being a member of the United Nations international force. Right? Whereas both levels of government derive their authority from the sovereign, neither can unilaterally change the relationship. That just means that the national government can't modify the powers of the states, and the state governments can't modify the powers of the national government. Let's say for whatever reason, this is very unlikely to happen. Texas is one of the few states in the country that does not have a personal income tax. I think there's only 6 states that remain that don't have a personal income. When you file your income taxes, if you live here in Texas, you file a federal income tax return. If you live in most other states, California, let's say, you file a state return as well. So when I say that this doesn't seem very likely, I'm literally mean. I can't imagine this happening. This is a purely hypothetical. in my lifetime, I can't imagine, I hope I have a few years left. I can never imagine Texas adopting a state income tax. Things would have to get pretty bad here in Texas that would convince the leadership here in Texas and Texas voters that an income tax was in line. But let's just play the hypothetical. Texas adopts this income tax. We know that it's final and supreme because it is within Texas constitutionally assigned sphere. But as a result, it's not like Congress can say, you know what, we're just going to repeal the authority of Texas and all other states to adopt income taxes. They can't do that. The national government can't do that unilaterally. Can the powers of the national government be changed? Can the powers of the state government be changed? Yes. How would that happen? Formal constitutional amendment. And what has to happen in order for an amendment to be added to the U.S. Constitution? Like, say, the 16th Amendment, which gave Congress the authority to impose a federal income tax. How does that happen? Remember, we were talking last week, very, very briefly alluded to the fact that it's a two-stage process, right? Formal proposal. That amendment has to be formally proposed. Who does that? Congress, 2/3 vote in the United States House of Representatives, 2/3 vote in the United States Senate. That's the national government's action. And then how is it ratified? 3/4 of the states have to ratify it. So it's bilateral, right? The key word here is unilateral. Powers of the state governments can be changed. The powers of the national government can be changed, but not unilaterally by one level. Okay? It has to be both levels of government. In fact, it takes extraordinary majorities to do it. All right, finally, the regional governments in the United States, the states, exist in their own right. So that means that once the people of a state become part of the union of the people of the states, like Texans did in 1845, they can't be abolished, right? It's not like they can say up in Washington, we've had it with you people down there in Texas, you're out. You're no longer part of the union. They can't do that. But the other side of the coin holds as well, and you should be aware of that, okay? Once the people of a state, as Texans did in 1845, become members of the union of the people of the states, they can't secede by their own resolution, despite what Texas and other southern states attempted to do in the Civil War. Yeah, I understand the Civil War was about slavery. It wouldn't have happened without slavery, but it was also very much about this question of whether or not states can secede. It was Lincoln's position, an equivocal position, that the people of Texas, the people of South Carolina, the people of Georgia, the people of Tennessee cannot secede just because they vote to secede. It took military conquest to prove that point. But that was a very important principle for Lincoln. So despite what sometimes Texas governors say, remember when Rick Perry, y'all remember Rick Perry, Mr. Hair, governor with the hair? Before the current governor, Abbott, he would go around the country talking to various business groups in California, presumably trying to attract business to Texas, lure it away from California or New York or wherever it is and bring it to Texas. But he would say things like, Texas just might secede, which one suspects politicians know what they're doing when they say stuff like that, right? That they're just sort of pandering to a particular audience. But if the Civil War means anything, Texas can't secede. It was actually a very interesting case decided by the United States Supreme Court in the years just after the Civil War. Civil War ended in 1865. This case came before the Supreme Court in 1870, called Texas versus White. It's a very complicated case, but basically the state of Texas was trying to argue that some contracts that it entered into during the period of the Confederacy, they weren't obligated under the Constitution's provisions for, states' obligations of contracts. And the state of Texas argued before the Supreme Court, well, Texas wasn't part of the United States at that time. How can the Constitution apply? And the Supreme Court very firmly said that you may have thought you seceded, but you didn't actually secede. All right, so how does the Constitution divide powers between the national government and the states? If the simplest definition of federalism is the constitutional division of powers between two levels of government, central and regional, then how does the United States Constitution do that with respect to the national government and the state governments? At first glance, it seems very simple. Okay, so let's get the simple stuff out, and then we'll get the complications. The theory of the Constitution is, in its origins, is that whatever power the national government has is delegated by the Constitution or enumerated in the Constitution. Okay, I'm going to say that again. The theory of the Constitution, at least in its origins, is that whatever power the national government has, whatever power the national government may legitimately exercise, is delegated by the Constitution. It's enumerated in the Constitution. That word enumerated means that you can read the Constitution from the beginning to the end. When you encounter the first power delegated to the national government, you say, oh, there's number one. Keep reading. There's number two. There's number three. There's number four. So that by the time you finish reading the Constitution, you would have some finite number. I don't know what that number is. I've never done that exercise. And whatever powers are not delegated to the national government are reserved to the states. Anything that the Constitution doesn't delegate to the national government is by default a power that's reserved to the states. That is the basic theory. I keep saying in its origins because remember I told you last week that we said that the powers of the national government are plenary. Remember that word, plenary? He said it means that the emphasis is really on denials of authority rather than grants of authority. But now I'm telling you something that sounds very different. What I'm really trying to tell you is that this theory began to break down almost immediately, so that the powers of the national government became plenary almost immediately with the ratification of the Constitution. But boy, if you could go back in time and ask Mr. Madison, the father of the Constitution, about this theory, he would be unequivocal on it. In fact, he was in the Federalist Papers. He would say, look, the national government only has the powers that are in the Constitution. Show you what I'm talking about. Here's a transcription of the Constitution. Get this big enough here so everybody can see it. Article 1 says all legislative powers herein granted, herein delegated, herein enumerated, okay, shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And now we're going to scroll down to section 8, and it begins to enumerate the powers of Congress. The Congress shall have the power to. Well, what shall the Congress have the power to do? Lay and collect taxes, to pay the debts of the United States, to provide for the common defense of the United States, to promote the general welfare of the United States, to borrow money on the credit of the United States, to establish a uniform rule of naturalization, to coin money and regulate the value of money, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, blah, 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 blah. Okay? Provide for and maintain a navy, to raise and support armies, to declare a war. Those are the delegated powers of Congress. Where do you suppose we might go to find the delegated powers of the president? If we're finding the delegated powers of Congress in Article 1, where do you think we might go to find the delegated powers of the president? Like, say, the power to make treaties. or to appoint judges and ambassadors? Where do you think we might find that? Any guesses? It's not really a trick question at all. It's probably as obvious as you think it is. The delegated powers of Congress are in Article 1, specifically Article 1, Section 8. But let's just stay with the articles. Which article do you think deals with the delegated powers of the president?
Article
2. Huh? Look at this, though. We scroll all the way down. Look, here are the delegated powers of Congress. Everybody sees that, right? The delegated or enumerated powers of Congress. But if we scroll all the way down to Clause 18, look what it says. It says, Congress shall have the power to make all laws which shall be necessary and proper to carry into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. So let's break it down. As the sports guys like to do, huh? Break it down. What does this mean? Foregoing powers. What are the foregoing powers? Any thoughts? I'm always amazed by the kinds of things that people are either eager to talk about or shy to talk about. I suspect that maybe shyness or reluctance, shyness is probably not the right word, but reluctance to throw something out there is based on just a lack of confidence and that you might be right or you might be wrong kind of thing. But it's not because it's overly complicated. I mean, those sports guys that I mentioned a moment ago, they can really complicate, offense of the LA Rams. No problems getting complicated about that. You ever try to explain baseball to someone who doesn't understand baseball? The subtleties and the nuances of that game? So it's not of how complicated it is. This is no more complicated than any of that. Any guesses what? Don't be shy. Don't be reluctant. What do you think that foregoing powers is referring to? If I do this. That just makes you dizzy. Gary, I know you got it, right? What are the foregoing powers? All of the powers that are listed here in Section 8 preceding that clause, right? The first 17 clauses. So it includes things like the power to borrow money on the credit of the United States, the power to regulate commerce among the several states, the power to, raise and support armies and navies, etc. Those are all the foregoing powers. So you understand what this says? It says that Congress shall have the power to make all laws which shall be necessary and proper for carrying to execution the powers that are listed in these previous 17 clauses. So, for example, when the question came before the United States Supreme Court in 2012 of whether or not Congress had the power to require individuals to have health care insurance, Obamacare, right? The opponents of Obamacare said, in their arguments before the court, said, that's not in the Constitution. Where in the Constitution does it say Congress has the power to require individuals to have health care insurance? But does anybody know how the Supreme Court answered that question? Does Congress have the power to require people to have health care insurance? A conservative majority of the Supreme Court, Republican appointees to the Supreme Court, said that yes, Congress does have that authority. Or at least a coalition of conservative justices and liberal justices. Okay? Well, look what Congress does have the authority to do. Congress does have the power to lay and collect taxes. Okay? And if Congress has the power to lay and collect taxes, it also has the power to make all laws which shall be necessary and proper for carrying to execution its power to lay and collect taxes. So what the Supreme Court concluded was that you don't have to have health care insurance under Obamacare. You can choose not to have health care insurance. But if you choose not to have health care insurance, Congress can impose a tax penalty on you. Congress does have the authority to do that. When Congress passed the Civil Rights Act of 1964, that prohibited restaurant owners and people who operate bus lines and railroad lines and people who operate hotels and theaters and places of amusement, any sort of business enterprise that's open to the public. When Congress said in the 1964 Civil Rights Act, you cannot deny service on the basis of race, do you think that any of those business owners challenged that? Said, wait a minute, this is the United States of America. I run my business, right? And by the way, where does it say anywhere in the Constitution that Congress has the power to tell me I can't deny service on the basis of race? Well, when that case went, a couple of cases in 1964 went before the United States Supreme Court, they settled on this. Congress has the power to regulate commerce among the several states. And if Congress has the power to regulate commerce among the several states, it also has the power to make all laws which shall be necessary and proper for carrying to execution its power to regulate commerce among the several states. You see, people travel across the Georgia state line to check into the Heart of Atlanta Motel. That's interstate commerce. They travel from places like Oregon and Texas and Maine and other places around the country just to check into the Heart of Atlanta Motel. Or maybe coincidentally, they check into the Heart of Atlanta Motel. But the owner-operator of the Heart of Atlanta Motel says, if you're black, you don't get a room here. Congress says you're violating federal law if you do that. The owner-operator of the Heart of Atlanta Motel says, where does that say that in the Constitution, that Congress can do that? And the Supreme Court says, right here, okay? Here and here. What else does Congress have the power to make all laws that are necessary and proper to do? Not only to carry into execution the foregoing powers, those listed in the previous 17 clauses that are already powers of Congress, delegated powers of Congress, but all other powers vested by the Constitution in the government of the United States or any department or officer thereof. You know what? The president is a department or officer of the United States government. So if the president has the authority under Article 2, Section 2, Clause 2, he is the president, shall have the power by and with the advice and consent of the Senate to make treaties. And under Article 6, if those treaties are the supreme law of the land, this Constitution, any acts of Congress made in pursuance of the Constitution, and all treaties made or which shall be made under the authority of the United States as the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution of a state or the laws of a state to the contrary, notwithstanding. The Constitution of the United States is the supreme law of the land. Acts of Congress, if they are made in pursuance of the Constitution, are the supreme law of the land. Treaties made under the authority of the United States are the supreme law of the land. So if the United States enters into a treaty with Great Britain, if the president negotiates a treaty with Great Britain, as President Woodrow Wilson did back in 1916, for the purposes of protecting migratory geese, make their summer nests in Canada, and then when the weather turns cold, they migrate south to the Texas Gulf Coast, where their ancient migration patterns take them over a jurisdiction, a political jurisdiction called Missouri. And hunters in the state of Missouri point their guns up into the sky and blow them into oblivion in violation of federal laws that establish hunting seasons and bag limits and other kinds of restrictions on hunting the migratory geese. And they just say in Missouri, we don't care. The United States wants to enter into a treaty with Great Britain to protect migratory geese. By all means, go ahead and do it, but count us out in Missouri. We're not going to do that. Can they do that? Not if Article 6 means anything. All treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Missouri can't claim exemption. But you know what else? Not only is that treaty the supreme law of the land, but Congress has the authority here to make laws that put that treaty into effect. All laws necessary and proper to carry into execution the treaty-making power of the president. These are all provisions that were part of the original language of the Constitution. This is not constitutional amendment. What were the Federalists interested in? What do they teach you in the American history classes that the Federalists were trying to do? They were advocates of stronger national power. Do you think these provisions that I'm drawing your attention to accomplish that?
Yeah.
Yes, they do. Do you think the Anti-Federalists were idiots and they couldn't see that and they couldn't, draw inferences from what that would mean? They were not idiots. They could draw inferences, and that's why they were concerned about the ratification of the Constitution. Okay, so the bottom line, to get back to the original point, okay, the original theory of the Constitution is that the national government's powers are limited to those that are delegated in the Constitution, and that anything else was reserved to the states by virtue of the 10th Amendment, which we'll look at in the Thursday class meeting, right? However, there's a very open question that has been there from the very beginning. What is the extent of the powers that are actually delegated to the national government given this language? Does the Constitution actually delegate to Congress the power to require people to have health care insurance? Apparently it does. Does the Constitution actually delegate the power to Congress to establish closed seasons for migratory geese? Apparently it does, even though you don't see the words migratory geese anywhere in the Constitution. Does the Constitution delegate to Congress the power to establish a minimum wage? Apparently it does, even though you don't see minimum wage anywhere in the Constitution. And we could just keep going on and on and on with examples, but I think the point is pretty clear, right? That the question here, what I've suggested to you here is not wrong, okay? It's just a question about what's included among the delegated or enumerated powers. And that's where we go back to the term that I threw out there for you last week, becomes relevant. Because almost immediately has a practical application of Article 1, Section 818, sometimes called the Doctrine of Implied Power, sometimes called the Elastic Clause, okay? Sometimes called the Necessary and Proper Clause. You've heard it by all of those, I'm sure, in your other classes that you've taken, right? The implication is that the powers of the national government are plenary. We did throw that term out there last week, right? As long as it's not specifically denied, as long as there's some reasonable basis in the Constitution, then the national government can undertake that authority. Questions, comments, thoughts? So, look, in the Thursday class meeting, what we're going to talk about in more detail is, let me get to the spot here. We're going to talk in a little bit more detail about the provisions of the Constitution, the U.S. Constitution, that are relevant to this, and then we'll move to a discussion of how federalism works at the state level here in Texas. Okay? We can knock off a couple of minutes early here. I think that's a good stopping point. Be sure and watch the Thursday video to get the rest of the story.